Moratorium and the Emergency Rental Assistance Program, which we passed and the governor has announced will open on June 1st. So we wanted to make sure everybody understood, what has to happen and how you can be helped by this. Before I go into more detail, I want to make sure, again, that our Spanish speakers joining us know that they can click directly on the Zoom link for the event and select their preferred language at the bottom of the screen for simultaneous translation in Spanish. And I also want to acknowledge and thank the hardworking staff and attorneys at Legal Services of the Hudson Valley, who you are getting a chance to see on the screen right now. They'll be leading this very informative discussion and they'll be answering your questions. And of course, I want to acknowledge the new CEO, Rachel Halperin, and she's not on tonight's Zoom, but she's ensured us that Legal Services of the Hudson Valley continues to thrive and provide legal services to those who otherwise cannot afford an attorney. They continue to fight the many inequalities we've seen made worse during this pandemic. In Albany, we are working every day to tear down barriers, and this pandemic has really highlighted many of them, including the longstanding inequalities faced by low-income individuals and families already struggling to get by. That's why we brought to the floor and passed the strongest anti-eviction legislation in the nation during the pandemic, and we've extended it. The law says that tenants who are facing economic hardship due to the pandemic cannot be evicted until August 31st, 2021. This law, of course, also applies to homeowners, small businesses, and small landlords. There could be no greater priority than ensuring that everyone has access to a stable, safe place to live. And so this legislation offered a lifeline while people are having an opportunity, hopefully, to get back on their feet. So it was common sense for us to do it. We came in last year before the year's end in order to extend the moratorium, and we've extended it again, as you know, during the budget. The Center for Disease Control have specifically found that permitting evictions increases the spread of COVID-19 and that moratorium laws like New York's work to prevent the transmission. Aside from the legislation, though, it was important that we had resources to help people. And so I want to really thank our congressional representatives, Senator Schumer, Senator Gillibrand, and our local Congress people, Jamal Bowman, Congressman Bowman, and Congressman Mondaire Jones, because the work that was done on the federal level brought us $2.3 billion in emergency rental assistance that we passed through the state budget, and we added another $100 million of state funds for tenants and landlords ineligible for the federal money. This rental assistance goes directly to the landlord, who must agree to waive any late fees that are due on past rent and not increase the tenant's monthly rent or evict them for a year. Program can also provide an additional 3 months of future rental assistance to households who dedicate 30% or more of their monthly income towards rent. And you can qualify regardless of your immigration status. The program is expected to help up to 200,000 households, and we will be monitoring on the state level this program very, very closely. In case you didn't know, but I'm sure most of you know, I lead the New York State Senate and I lead the Senate majority. And we've made it clear that we're committed to placing New York on a strong path to recovery. And that means supporting everyone in need as they come out of this pandemic. I've been an avid supporter also of the legal services of the Hudson Valley over the years, securing millions in funding Just recently, 400,000 for housing and kinship care, 90,000 for domestic violence, 380,000 for veterans and military families. And that's just in the Westchester Rockland area. Across the state, over $3 million has gone so that the legal services of the Hudson Valley can do pretty much what they're going to help do tonight. So we do this because we know government cannot do everything by itself. We need partners, and legal services of the Hudson Valley have been incredibly strong partners in every area. So now I'd like to turn it over to my friends at the Legal Services of the Hudson Valley, and we could start by hearing from the supervising attorney, Christopher Schweitzer. And thank you so much, Christopher, for doing this.
Thank you, Majority Leader. And I'd first like to start by thanking you both for working so hard to pass these eviction laws in New York, and for your ongoing support of legal services of the Hudson Valley. As you so elegantly explained, we really can't do the work that we do every day without your ongoing support of our mission. And it's just so critical to our success that you continue to do so. And we're just so appreciative of everything that you've done for us so far. So thank you for all of your support and for everything that you've done for tenants in New York, keeping people in their homes during this incredibly difficult time during this pandemic. So without any further ado, I'll introduce the panel that'll be presenting tonight. First, we have Marcy Kobach, who is our Director of Litigation at Legal Services of the Hudson Valley. We have Sumana Ragnachar, who is a staff attorney in our Yonkers office, Michelle Sagiv in our Mount Vernon office, Lauren Johnson in the White Plains office, and Andrew Glicken-Gazinski in our Peekskill office. And I will turn it over to Marcy to start the presentation.
Thank you very much. I'm going to share my screen and load the PowerPoint. And while I do that, I'll just mention that there will be some time at the end for questions. And there's a Q&A function if you are on the Zoom. And we will, when we're finished with our presentation, address as many as we can. So first off, I just need to say we are attorneys, and we need to explain that we are providing legal information with this presentation. An attorney would never advise on an individual set of circumstances during a forum like this, but our contact information is going to be plastered at the end of this presentation so that people will be able to reach us. And what we do as the leader, thank you for that introduction of us and your support. We are a law firm that provides free legal services in civil matters, so not criminal matters. And housing is a big issue, and that's a lot of the work that we do. And we'll be talking today, my colleagues will be going into detail about the current housing measures, which the leader referenced. So people can contact us. They can contact our central intake line if they have any civil legal issues, but also housing issues. And what we will be reviewing today is New York State's COVID-19 Emergency Eviction and Foreclosure Prevention Act, focusing on the eviction prevention piece of it, because those are the experts that we have at the table here. We'll briefly address other measures affecting eviction proceedings which intertwine with this. Then we'll talk about New York State's COVID-19 Emergency Rental Assistance Program and just reference other sources of rental assistance. So with that, I'm going to turn it over to my colleague, Sumana.
Thank you, Marcy, and thank you, Christopher, and of course, our esteemed leader, Andrea Stewart-Cousins, for allowing us to have this opportunity to reach ourselves out to the community and talk about what is this New York State COVID-19 Emergency Eviction and Foreclosure Prevention Act. We at Legal Services call it CEFPA, just because it's such a long name. But it has such a profound impact on what's going on now because of the pandemic. There's so many things that have gone out of people's controls and have put them in harm's way. And it's this act is really important for us as attorneys to make the best decisions for our clients and for our clients to be safe and sound where they are. This was an act that was signed into law at the end of last year, December 28th, 2020. It was addressing the hardships that have come from the COVID pandemic. It was originally supposed to go through May 1st of 2021, but it was extended to August 31st, 2021. We have forms and information on the court's website. You see it right there. It's www.newyorkcourts.gov/EEFPA, stands for Emergency Eviction and Foreclosure Prevention Act. You will see a lot of information there, especially you will see a hardship declaration on that website as well. And we're going to be talking about it in a little while. This hardship declaration is for tenants who can swear truthfully under penalty of law that they have suffered certain types of hardship during the pandemic, or that it would be dangerous for them to make them relocate. And those tenants can sign this particular declaration. What it does, it gives them a little extra time. It gives them through August 31st, 2021, before they can be evicted. Now we're going to talk about the hardships. Well, what the hardships include: loss of income and increased expenses, which are not made up by benefits or relief programs. In other words, you might have, well, loss of income because you've lost your job, you've gone on hiatus or furloughed, or you cut hours, or you have increased expenses. You might have to take more expensive transportation where you're going because of the pandemic, or you might have to get childcare for your children who don't go to school during the pandemic, and that might be right out of your pocket. And that's what we're talking about when we talk about these hardships. Okay, now court cases come by in this time period in the eviction world only in very limited circumstances. If you are a tenant and you're in, for some reason, either you're not paying your rent or you have another reason to be evicted, the landlord can't come as easily and serve you with a new eviction case unless, the first thing that the landlord has to do is give you an opportunity to sign this hardship declaration. And they have to give you that opportunity because if you have a hardship, they have to stop and not bring that action against you at this particular time period. Well, if they do give you this opportunity and you haven't sent back the hardship declaration, and they can swear to that, the landlord can swear to that, that you have not brought back the hardship even though you were served the hardship. That's a way for a landlord in this time period now, between now and August 31st, to actually serve you with a new eviction case. There's another way. If it's a serious nuisance that they're alleging, they can serve you at this time with a new eviction case. And when I talk about a serious nuisance, this is perhaps something like maybe the tenant is sitting in their home collecting garbage over this time period, and there's a smell emitting from the apartment, which is becoming a nuisance to other tenants in the apartment building, and the landlord tells this tenant, you know, there's a nuisance and there's no cure. The tenant doesn't do anything about it, and there's this continued nuisance. That's something the courts are allowing the landlords to start eviction proceedings on, even in this time period. So the tenant can submit the declaration to the court or landlord after the court case has started, and it protects them from eviction until August 31st, unless the case, of course, is about the nuisance and the landlord can prove that this is an actual serious nuisance. So even if this tenant doesn't submit the declaration and the court issues this warrant of eviction, okay, you have that situation. They didn't submit a declaration. There's a warrant of eviction. Well, the tenant, even at that point, can submit the declaration of the hardship to the marshal or sheriff or constable, whoever the person is trying to lock them out of their home, or the court or the landlord at that time, because they are protected if they indeed have this hardship because of COVID. They can submit it at that time and not be evicted. There's this exception again, if the court papers have alleged a serious nuisance and the landlord has proved to the court that the tenant continues to create the serious nuisance. This is one exception, and the eviction can proceed between now and August 31st. So we're going to talk a little bit about this declaration. Maybe you have seen one. It's on that website that we mentioned before. It's a hardship that a tenant must swear to. They must sign it in good faith, and they can sign it and check off one or both of the sections on the hardship declaration. The first section, there's one section is a health risk, and that is vacating or moving would be a significant health risk because a member of the household has an increased risk for severe illness or death from COVID, because the member is over a certain age, 65, or has a disability, or an underlying medical condition, including being immunocompromised. So these are examples of when you can check off the health category on the COVID, on the hardship declaration, and give yourself extra time to recuperate from the situation that you're in because of the pandemic. The other way is if there's a financial hardship. Okay, so you are no longer able to bring in the kind of income you were bringing before. And so you don't have the ability to pay your rent in full or obtain alternative suitable housing due to the specific circumstances. And those we're going to continue discussing them in detail.
Thank you, Sumana. And for that detail, I'm going to turn it over to my colleague, Michelle, to go through those specifics and continue with more information about this law.
Thank you, Marcy. So there's many different types of hardships that are covered under the Act, such as when there is a significant reduction in the income during the time period of the pandemic. Also, if there's an increase in expenses related to medical impacts or due to having to perform essential work during the pandemic. Also, sometimes the need arises to care for others, such as family members or children, and that has led to a decrease in income or earning power and increase in expenses, as well as other COVID-related circumstances that have caused tenants to have an increase in expenses or loss of income. Importantly, tenants must declare that any assistance, such as unemployment benefits, that they receive does not fully make up for income that was lost or additional expenses that they incurred. And there are several considerations that tenants should think about before signing the hardship declaration, such as if tenants lost income, as mentioned on the previous slide. If tenants have experienced a loss of income, they should consider whether they received unemployment benefits or some other additional form of income, and whether that amount has made up for the reduction. Also, if they had an increase in expenses, tenants should consider whether additional government programs such as SNAP has helped make up for that increase in expenses. And if tenants were looking for housing and unable to find additional housing or alternative housing, can the tenant show that they have been searching? Can they document proof? Can they provide proof of the search? Also, tenants that are living in subsidized housing and lost income, they should consider if they reported it to the landlord and if they asked for an adjustment to the rent. There's also been other significant legislation that has passed as a result of the pandemic, such as the Tenant Safe Harbor Act, which was passed in May of 2020. And under this act, tenants can raise a financial hardship defense for rental arrears that accrued from the month after the pandemic to the times that all the restrictions on gathering sizes were removed. If the tenant raises this defense in court, they can be asked to provide proof. And if they do provide proof, then any rental arrears that accrue during this time, they can't get a judgment for eviction. They can only have a money judgment against them. Also, currently, due to the possibility that restrictions on the restrictions on gatherings, on the sizes of gatherings, will be lifted. It's possible that within this month, the restrictions could be lifted. And thus, if tenants owe money, for any rental arrears that are owed after the restrictions are lifted, they can get a judgment of possession against the tenant. And there's also been many changes to the way that courts are holding cases, as many cases are being held virtually instead of inside of the courtroom because of the pandemic.
Thank you. And Lauren will take it from here, but I believe we are going to switch interpreters.
Yes, we're going to do a 2-minute pause to switch interpreters. Okay, we're gonna begin now. I'm gonna first ask Marcy if you'll just advance. I think we're one more slide. And then just to let our participants know that you can ask any questions using the Q&A box below. And there will be time for a Q&A after, where we'll be going through any questions that have been submitted. Okay, so I'm going to be talking about the COVID-19 Emergency Rental Assistance Program. You're going to hear it referred to as ERAP, ERAP, and that's how I'm going to refer to it going forward during this. But just so you know, it's at the top of the slide, COVID-19 Emergency Rental Assistance Program. So this is a New York State program that has been set up from money allocated from the federal government. New York State is going to process applications for most of Westchester residents, with the exception for Yonkers residents. For Westchester residents, you are going to apply through the Office of Temporary and Disability Assistance website. That application is going to be going live on June 1st. For Yonkers residents, you'll need to visit the Yonkers City website. If you're a resident outside of Westchester, there are some other counties and cities like Yonkers who are administering the funding directly themselves, and a full list of those counties and cities can also be found directly on OTDA's Office of Temporary Disability and Office of Temporary and Disability Assistance website. That's another acronym that we'll be referring to as OTDA. So there are some factors of this program that are a little bit different to previous programs or other rental assistance programs that are out there. First, as stated earlier, immigration status is not an eligibility factor. A tenant does not have to have a current signed lease, nor is there a requirement that they previously had a signed lease that expired. Tenant does not need to already be in an eviction proceeding. Money can be paid for rental assistance, not mortgages, and this will include apartments, single-family homes, and mobile homes. The rental, it won't cover any rental arrears that occurred prior to March 13th of 2020. Tenants can only get assistance for their current landlord. So if rental arrears has accrued and the tenant has since left, if they're no longer residing and that landlord is no longer their landlord, they won't be eligible for the program for that landlord where the arrears accrued. And money can be paid for utilities, but this excludes water and internet bills. So the eligibility for the program is going to be that you are under 80% area median income. And in Westchester, for a family size of 1, that's going to be $63,400. It goes up by approximately $9,000 per family member. These numbers, they vary by the county. And again, there is a chart on OTDA's website that you can review for different counties and different family sizes. It also requires someone in the household to have suffered a financial hardship directly or indirectly related to the pandemic. This could be that someone qualifies for unemployment benefits or can show a reduction in hours and therefore wages or income, or someone who's incurred significant costs, maybe from childcare, as we mentioned previously, or medical costs. And another factor is they must be able to show that they are at risk of homelessness or housing instability, which can be demonstrated simply by having rental arrears that are owed after March 13th, 2020. And then families who get assistance under this program, they can also be qualified for assistance for utilities. So if you get assistance for rental assistance, you can also be qualified to get utility assistance as well. And then for the state program that's going to be administered by OTDA, within the first 30 days, there is going to be a certain priority order, but tenants should not wait to apply. The priority orders are only for how the agency will process and not how someone should apply. So if you look at this slide, I'm not going to go through them, but it does state out what some of the priorities are. And in the second bullet point, it does say what the priority will be for the program that's going to be administered directly by the city of Yonkers. And as I stated, that is just the priority is just going to be run by, OTDA or Yonkers City, and the priorities aren't necessarily how a tenant should apply. When the applications become live, the tenant should apply right away.
So, my name is Andrea Kusinski. I'm one of the staff attorneys, as already introduced. I'm going to go over some of the priority factors. So, for ERAP, priority factors are if an individual is currently unemployed and has been for at least 90 days, or if that individual is a veteran, or if they are currently experiencing domestic violence, or if they are a survivor of human trafficking, or if they have an eviction case currently pending in court that's related to the property they're currently residing in, or if they reside in a mobile home, or if they live in a community that was disproportionately impacted by the COVID-19 pandemic, or if the property they live in is a dwelling of 20 or fewer units. For the state program, individuals with Section 8 or who reside in public housing or other tenants who pay their rent based on a percentage of their income can only receive assistance from ERAP after tenants in the other priority categories have been evaluated and if there's any money left over after that point. For Yonkers, it's a little different. For the Yonkers program, applications from Section 8 tenants, individuals in public housing, or other tenants who pay their rent based off a percentage of their income are accepted the same way as all other tenants. The payments can be made for a balance of the tenant share. Any tenant who has not yet reported a loss in their income should report it as soon as they are able to, and any tenant who has reported a loss of income but has not yet been recertified should follow up regarding that recertification so their tenant share is properly calculated. Excuse me. Tenants will need to provide several forms of documentation for the ERAP program. The information that they will provide will be kept confidential. A tenant may attest to certain information. For example, they can attest to how they were impacted by the pandemic, or they can attest to whether they have experienced domestic violence. Landlords will need to provide certain information for the ERAP program, and OTDA is responsible for making those inquiries to the landlord and following up with the landlord for the requested and required landlord information. Payments from ERAP can be made for up to 12 months of rental arrears or back rent, and potentially for 3 months of future rent. The future ongoing rent can only be applied for families who are paying more than 30% of their monthly income towards rent. Individuals who receive funds from the Division of Housing and Community Renewal can be assisted by the program. However, tenants cannot receive funds from this program at the same time as they're receiving funds from a different program for the same months of back rent. So you can't get the same amount from two different programs for the same time period. If a landlord is not providing the requested information for ERAP, a tenant can later raise this as a defense in an eviction matter. For any questions regarding how to raise that defense or any other defense in an eviction matter, tenants are advised to reach out to legal services of the Hudson Valley. There are other potential forms of rental assistance out there as well. The Department of Social Services is able to pay arrears for eligible tenants if they are low income and can show the ability to pay the ongoing rent in the future. DSS usually applies a 4 to 6 month cap. For individuals who owe more than 4 to 6 months, if they're able to obtain assistance through a different agency, DSS should be able to then help. Tenants who are not eligible for assistance from the Department of Social Services may be eligible for their program, and DSS usually makes referrals to agencies who run other programs. Some examples of those other programs would be the Bridge Fund, or Catholic Charities.
Thank you. So that concludes the basic information that we're providing here, and we have some time for questions before the majority leader wraps up the program. And I am continuing to share my screen so that our central intake number and our website are visible, and also the list of where our offices in Westchester are. I did see that there's a very good question regarding the resources being available through the internet. So the hardship declaration forms are on the court's website, and they can be available in person in the courthouse. The courthouses are on full staff as effective of this Monday, May 24th. As for the ERAP assistance, the application portal is online. However, what the state has done is work with, community organizations, the organizations that are already connected to the tenants who are likely to be in need, to assist people with those applications. And then I guess, Christopher, if you wanted to take the next question.
Yeah, Marcy, I was just going to add to that there is a section on the OTDA website with partner organizations in each county that is now up. So that might be helpful for getting the ERAP application if you can't get it online. And there's also a phone number that you could call. So let me take a look. What court could I go to in Westchester to receive a hardship declaration? So you can go to any Westchester City or Justice Court to get a hardship declaration. So essentially any court that hears landlord-tenant matters should have hardship declarations at their court. The clerk's window should have them to complete. And like we said in the presentation, if you're receiving any type of court papers, you should also be receiving a hardship declaration prior to anything happening. Or if you go to court, the court should also be offering you a hardship declaration at that time, but any city or justice court should have the hardship declarations readily available.
There was a question, if somebody has trouble with the rental application assistance, should they call LSHV? I think first contact the agency in your community for assistance, but certainly it's a priority for us that everybody gets, as many people as possible are assisted by this program. So we would certainly take the call. Christopher, I think a couple more questions have rolled in while I answered that one.
Yeah, I'm taking a look here. Someone is, okay, so a question about if you're owed unemployment but haven't yet received it, how would you prove your income for the rental assistance application? That's definitely an issue that some New Yorkers are facing. I imagine that the application is probably going to want some sort of verification from the unemployment system. So any type of either approval, denial, payment history, anything that you can get from the unemployment system is probably going to be helpful. If it shows something like, payment status not found, or maybe application pending, I think that they would probably have to take that, but they also might, take that and then follow up with additional information needed, if that's the case.
Okay. And then there was a question about if you're being evicted, should you remain in your home? Essentially, an eviction is a legal process. So the correct process has to be gone through, and the person continue to live in the home. They might receive a notice that they're being asked to leave, but that doesn't have the legal effect of requiring the person to leave. There's a process in court, and it has to be worked all the way through. So a letter saying, I'm going to evict you, that would not, and then if that would not be a lawful eviction because it doesn't go through that court process. So then similarly, there was a question, the question was phrased, I should complete the hardship declaration and apply for rental assistance on June 1, ? And I can't speak to your specific circumstances. However, you should review the hardship declaration, and if you can truthfully, under penalty of law, sign that this applies to you, you can submit it now. And absolutely, the rental assistance portals are going live on June 1st. So absolutely, there's no need to wait to apply. If looking at the criteria, it appears it would be likely if you qualify. Christopher, do you want to take the next one?
Let's see. Do you want to take that one?
Okay. So if the person has concerns about being undocumented, how is somebody protected? Certainly, immigration status has absolutely no effect on an individual's rights under New York State's landlord-tenant law. So I talked about there being a court process, a legal process that has to occur correctly for an eviction to occur. And none of those laws discriminate based on immigration status. And I don't think we can stress enough that anybody, that immigration status has no impact whatsoever on eligibility for the rental assistance program. Have there been any questions from the Facebook participants? I don't believe we can see directly.
We're sending them into the chat. So you answered some of the Facebook questions. Thank you.
Terrific. Okay, so I am going to cease my screen sharing.
So I guess, are we pretty much done with the question and answers, it seems?
Looks as though we covered the ones that came in.
Well, good. So it means that you have all done a spectacular job. So I want to thank you all, Christopher and Marcy, Sumana, Michelle, Lauren, and Andrew. I really appreciate your, taking the time to make sure that people understand that there is an opportunity here, and take that opportunity when it comes on June 1st. I know that nobody asked the question, and maybe they would have thought it would have been rude had they asked, but the reality was that when we did our first assistance at the end of December, it was very hard for people to get that money. And part of the problem was that we just really didn't have a lot of resources. It was right before budget time, and we had not gotten any federal help. So we only had about $100 million, and we put that through the Housing Commission. And it was very tough because it really wasn't a lot of money and there was a lot of need. So I'm happy to say that this round, and as you said, we extended the eviction moratorium from May until August because I have federal partners who actually sent resources, and those resources are going through, as I guess Lauren was calling it, OTDA. We call it OTDA. It's Office of Temporary Disability Assistance. But the good thing about OTDA is that they are used to handling emergencies quickly, and they have a system that's pretty well set up. So not only do we have more resources thanks to the infusion of federal cash, but we're also dealing with an agency that traditionally deals with emergency situations and can do this rather quickly. So I believe that people have a good opportunity to get the resources if you apply. But I think it was very clear from our attorneys that you have to make sure, if you don't know, ask. There are ways for you to ask. I believe the information has been given where you can contact Legal Services Hudson Valley. My contact information is also in the chat, and in my office we also speak Spanish. So if you have questions, ask the questions. Don't make mistakes you don't have to make. And if you are in need, this is for you. So we want you to get the help that has been made available. And hopefully, if we all work together in concert, we will be able to not only get out of the pandemic, but get out of the housing insecurity because we've gotten help, and get back to having a good, healthy life. So that's really all that I have. I don't know if any other questions have come in the interim. If not, we can call it a night. Anything new?
It appears as though we have addressed them all.
All right.
Thank you so much.
Wonderful. Well, thank you again. It's always a pleasure doing business with you, and thank you for rising to the occasion, and have a very good weekend and a good Memorial Day, and stay well. And anybody who hasn't gotten vaccinated, get vaccinated. Okay. Take care, everyone.
Thank you.